Okay, we get asked a lot of questions about probate, but I took probably 7 of the most commonly, most frequently asked questions that I get, that our firm gets about probate in Florida, and I wanted to answer those here. So question number 1, what is probate, right? That's probably number 1. Probate is just a legal process that happens after a person passes away if they had assets that have to be transferred to the beneficiary. So most common example, mom and dad, they own a piece of real estate. They own their home here in Florida. They're both on title, which is pretty common. Dad passes away, mom now becomes the sole owner, and usually, again, if the title had mom and dad both on there, there's probably no probate necessary at that point. Mom, she's still alive, she owns the property. But when she dies, that property is now owned by her estate. And so her kids, in order to get that property put into their name, have to go through probate in order to transfer the real estate to their name so that they can sell it, rent it out, or do whatever they want with it. So probate, what is it? It's just a process, a court process, as far for the court to basically say who gets what of a person's stuff after they pass away, and it's really just transferring ownership of those things. Number 2, is it ever too late to start a Florida probate? Right? So we often get calls where someone maybe died, 2, 3, 4, 5, 10 years ago. Can they still do it? Yes, there is no time limit on when probate can be started. That being said, there are a couple practical matters. Number 1, if the person had money in a bank account, the bank is probably only going to keep that money for a certain amount of time before they turn it over to the state of Florida. And then after a certain amount of years, generally 10 years, the state of Florida keeps that money and you can't get it. So there is a practical matter there. Again, with real estate, someone's got to be paying the property taxes. The insurance might have to get paid. If there's a mortgage, obviously that's going to have to get paid, or at some point the property would be lost, most likely to some sort of foreclosure. But if that's getting paid, you could do the probate 20 years from now, and that wouldn't be an issue. So there's really no time limit on that. Number 3, do you need an attorney to go through probate? Maybe. It depends on the type of probate that you do. It depends on the judge. It depends on the situations. Generally, I will say yes, the court is probably going to require that you get a probate attorney. As a practical matter, it's just going to make your life a lot easier. But if you don't have the resources, or maybe you're, an attorney from another state and you think you can handle it on your own, it's very possible that you could, but there are instances where the judge is actually going to say, nope, sorry, you can't do this on your own. You're going to have to hire a probate attorney licensed in Florida. Number 4, how long does a probate take in Florida? Well, I'm seeing them take longer and longer. When I first started doing this many years ago, I used to say, hey, we get everything done in 6 to 8 months. They're taking longer now. It's a combination of, it's just the huge volume that the state of Florida has with regards to probate. I'm seeing more and more siblings hire attorneys to try to contest probates. They're just because banks, as far as liquidating accounts, are taking longer and longer to do that. So most of the probates that I'm seeing are probably taking 9 months to maybe a year, if not a little bit longer, to actually finish. It really depends on the situation, really depends on the facts, but I'm seeing probably that 9 to 12 months being more common as far as how long they take. All right, number 5. What parties are involved in a Florida probate process? Well, you're going to have a judge. There's always going to be a judge involved. You're always going to have the beneficiaries, whoever the beneficiaries are. You're going to have a personal representative, and so that's the person who's in charge of actually administering the estate. That person's usually the one hiring the attorney. They might have been named in the will as the personal representative, or possibly what is also called the executor. And then there's going to be an attorney most likely involved. Number 6, who cannot be the personal representative? Get this question a lot. Well, if you're a convicted felon, you can't be the PR. You're not going to be allowed to be the personal representative. If you live in another state, okay, you're not a resident of Florida, and you are not related to the person who died, you cannot be the personal representative. Now, if you live in, let's say, New York, you're not a resident of Florida, but your mom is the person who passed away and you got to do a probate for her in Florida, you can still be the PR. That's fine. You just can't be a non-resident of Florida and also not be related to the personal representative. And number 7, who can be the PR if there is no will? So there's a hierarchy in Florida. We call this intestate as far as who can be the PR and who gets to be the PR. If there is no will, first it's going to be the surviving spouse. He or she has priority. If there is no surviving spouse, then it's going to be whoever the majority is, right? So whoever the next of kin kind of get together, there's 3 brothers and 2 of them, and they all say that they want one brother to be the PR, he would have priority. And if there is no majority, then it's going to be the next of kin, and the court is ultimately going to decide. And again, there's a hierarchy as far as, parents, brothers, cousins, and so forth, as far as who can be the PR. So there you go. 7 of the most frequently asked questions that we get at Stiver's Law as far as probate here in Florida.